He indicated he may not want the services of the public defender anymore.
Letter, and I pleaded guilty on all charges, sir. So I figured I didn't need a public defender to plead guilty.
Why do you want to plead to 2 felonies? Okay, hold on.
Okay.
Thank you.
Welcome.
Mr. Wilson, can you state your name, please, sir?
Eric Wilson.
Thank you. Why was the first thing that came to your mind cutting off each other?
No, he said he didn't cut off.
No, I know he didn't say it, but why decided? I think the bond is reasonable. Motion denied. Let's call the case of the people of the state of Michigan versus Anthony Charles Holston.
Jacob Kennedy for the people, Your Honor.
Good morning, Your Honor. And there Tanazi Kiriak and really on behalf of Mr. Anthony Holston should be appearing from MDOC, Judge.
Yes, he is, and I have to start my day with you.
It's going to be a great day, Judge.
Yeah, I can feel it. Mr. Holston, can you state your name, please, sir?
Anthony Holston.
Thank you. I have before me a plea form that indicates that the defendant is going to plead to the charge of aggravated assault, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement, and there should be a sentencing judge waiver. Or no? What are we?
Yes, Judge.
Well, that's okay. The boxes are checked, but it's not my case. All right.
And this should be a no contest plea. Is that right, Judge? Do you have
Contest. All right. Mr. Holston, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the hope you got?
Yes, sir.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. Do you understand what a no contest plea is, sir?
Yes.
All right. 2 things about it I have to make sure that you understand. The first thing is that it first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that, sir?
Yes, sir.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Okay.
You understand that?
Yes.
Right. Basis for the no contest plea?
lack of recollection, Your Honor.
All right. To that charge, sir, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind?
Yes, sir.
All right. You had signed or had signed on your behalf an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
You understand that you're giving up all of those rights, including the rights contained under paragraph 5?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes.
Court has been provided Ann Arbor Police Department report for their case number 2461658. Any objection to the court having reviewed that report?
None, Your Honor.
From defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Is counsel aware of any other promises, threats, or other inducements that have led to this plea?
Your Honor.
And have I complied with the court rule?
Defense is satisfied.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be
July 17th at 8:30.
July 17th, 2026, 8:30. before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you, Mr. Olson. Oh, good morning.
This morning.
Court calls the case people versus Stephen Huska. I heard what Ann,
So, Your Honor.
I heard what Ann was saying.
Jessica McFarland requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Michael Gaddy.
Really? How is he as a supervisor?
Hmm.
Yeah, okay. Permission to practice is granted.
Oh.
Wow.
Brother, friend, I get that same review.
Yeah.
We have the defendant state their name.
Huska? Oh, they're in there doing it now. Thank you, officer. Mr. Huska, state your name, please.
Steve Haska.
All right. And what are we doing?
We are requesting to adjourn for further negotiations with the people.
Do we have a green sheet?
Yes.
It's gonna hold it.
Sorry.
Eddie tape.
No.
Let's see. July 9th work.
Yes, Your Honor.
Matter will be adjourned without objection to July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you. Court does call the case of the people versus Sarah McCormick. Ms. McCormick, can you unmute? State your name.
Hi there. I'm Sarah McCormick.
Thank you. All right, what are we doing?
Good morning, Judge. I spoke with the prosecutor, and me and the prosecutor have been working together, and she offered me a deal to reduce this down to a misdemeanor for controlled substance use. I haven't had the chance because we just spoke with the prosecutor yesterday. It was pretty late, and so I just need
So
to.
you did an adjournment?
Yeah, just an adjournment so I can just go over this with my client and then come back here for the conviction.
Will July 2nd work?
Yes, Your Honor.
Probable cause conference will be adjourned July 2nd, 2026, 9 a.m. Bond continued. Thank you, Ms. McCormick.
Thank you.
Court calls the case, people versus Matthew Kennedy.
Good morning, Your Honor. May it please the Son before David Bird can be up a minute. Oh, wait. Not too many,
Your name, sir?
Matthew Kennedy. Your Honor, we are asking for an adjournment of the probable cause conference. My client did complete Bear River and it might work into the plea, but the prosecutor needs the proof of that, so I need to get it from my client.
All right. Couple of work.
Yeah, I did want to address Bond if we could just briefly.
I'll adjourn these matters to July 2nd, 2026, 9 a.m. As the bond.
Thank you, Your Honor. Judge, my client failed to appear on a date. He had called me later that day, got his dates mixed up. Tried to walk him in on a Wednesday, but he was not able to meet me at the one Wednesday. I was able to do it that day, but did complete Bear River, Judge, and he did contact me. These aren't assaultive cases. I understand the concern the court might have, but does have stable residence area, and I think he will return, Judge, based on.
So how do you come into custody?
I don't. How'd you get? I was at work. Picked up at work. Yeah, picked up at work.
They just came and got you?
Yeah, I didn't cut my tether off or nothing. I didn't like abscond. I didn't.
He had a tether on, Judge. I mean, yeah, it was pretty easy to find, I guess. So.
Yeah, didn't die or nothing. I kept it charged. I kept doing my weekly check-ins. I kept going.
Why was the first thing that came to your mind cutting off your tether?
No, he said he didn't cut off.
No, I know he didn't say it, but why did that come to mind? Never mind.
Because I didn't.
It's context, Judge. That's all it is. Context.
Yeah, like I wasn't trying to go on there. Oh, sorry.
You're good.
Anything from the people on the.
No, you're wrong.
All right. What I will do is I will reinstate the defendant's previous bond in this matter.
Thank you, Your Honor.
Thank you.
Thank you. Hey, you know, let yourself.
You want me to change my mind or?
No, he said thank you. Your Honor.
Oh, I know it says if it doesn't go, I'm going to change my mind.
Leaving quickly.
Yes. Court does call the case, People versus Robert Anderson.
Your Honor.
Good morning again, Your Honor. May it please the Honorable Court, David Burgess, on behalf of Robert Anderson, who's appearing via Zoom, Your Honor.
Hello, Robert Anderson.
Okay, thank you. All right, what do we do?
Your Honor, the people have indicated to me that there's some additional discovery we're going to have to review and obtain prior to the exam, so we're requesting another adjournment of the probable cause conference.
How much time are you going to have?
Should be not this, a couple reports from YPD.
All right.
Which is fine, Your Honor.
Probable cause conference, July 2nd, 2026, 9 a.m. Bond continued.
Thank you.
Thank you. Court does call the case of the People versus Charles Johnson.
Your Honor, as about the people.
Oh, on behalf of Mr. Johnson, who'll be approaching the podium and standing to my right. Mr. Johnson, once you get up here, please state your name for the record.
Was that supposed to be her case and you took it, Felta?
Yes, Your Honor.
Lady, where are you from? Okay, don't let her do that to you. All right, go ahead. I'm sorry. Your name, sir?
Charles Bernard Johnson II.
And Your Honor, at this time, we are asking that the matter be set for exam.
Discovery is complete.
To my knowledge.
We were on June 30th.
People have their witnesses available June 30th? All right. Preliminary examination will be set June 30th, 2026, 9 a.m. before Judge Washington.
Thanks.
Bond will continue. Thank you. Court calls the case of the People versus Amanda Brown.
Your Honor.
Morning again, Your Honor. May it please the Honorable Court, David Burgess, on behalf of Amanda Brown, who's approaching.
Your name?
Amanda Brown.
All right, this is a waiver.
Yes, Your Honor.
Ma'am, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand that you'll not have that hearing. You'll proceed to circuit court for further proceedings.
Yes, sir.
People also waive their right?
Yes.
Yes.
Not had official offender notice as well as an agreement. My understanding is that it's currently on probation at circuit court. There would be an agreement to have her have concurrent probation, no upfront jail with her parents.
That's our understanding as well, Your Honor.
Preliminary examination having been waived, defendant's bound over to circuit court on a single count. Mr. Burgess.
Waive formal reading, stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 11th at 1:30 with Judge Confiance.
August 11, 2026, 1:30.
Okay.
Bound continued.
I'll call you.
All right, I'm done.
Court calls case of People versus Douglas Hill.
Over for the people, Your Honor.
And Assistant Public Defender Zach Venue with on behalf of Mr. Hill, who approaches on the case ending in 163.
Morning, Your Honor. Jay Grant, number P58658 on behalf of Mr. Hill on 2111.
Douglas Hill. Thank you. Both of you are requesting an adjournment.
Your Honor, yes, we're trying to keep the cases together, and I believe I spoke with the prosecutor this morning, and she's still waiting on a CCTV video. And as soon as that happens, we'll set for exam.
How much time are we going to need to get that?
Spoke with the agency yesterday. They indicated that it was just processing.
It was on.
The request, they had uploaded it, but it's processing.
Got it. So a couple weeks, you think, gentlemen?
I would defer to the prosecutor, Your Honor.
Pardon?
Good, Your Honor.
All right. Probable cause conference will be adjourned to July 2nd, 2026, 9 a.m.
Thank you, Your Honor.
Bound continued. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Morgan. Is it G-Lander?
Morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Morgan Jalander.
Your name?
Morgan Jalander.
You're requesting an adjournment?
Yes, Your Honor. 2 weeks is okay, Judge.
Your work.
I think I'm,
Probable cause conference will be adjourned July 2nd, 2026, 9 a.m. And will continue.
thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Safara Kent.
Jacob Kennedy for the people, Your Honor.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Kent, who's approaching, Your Honor. State your name for the record.
Safer Kent.
You're requesting an adjournment. Will 2 weeks be enough?
Would that be enough to get him?
Oh, you need,
Your Honor, I believe there's some additional charges coming.
That is correct.
So I don't know if they'll be able to get him arraigned on those, but I would think 2 weeks, depending where they are in the swear-to process.
My understanding that search is going to take place this interim. So
okay, is he then set to be, the swear to will happen, is he set to be arraigned this afternoon?
that, no, Your Honor, just swear.
Purchase an offense is complete. Right.
That's correct. There are 3 additional.
Gotcha. Okay. And so that this wasn't on where the officer was on call.
No, but for this was not.
Got it. Okay, so that's where two is going to take place. You would then have to on those charges. I don't. You want me to put it out 2 weeks or 3? Because here's the reason I'm asking. I don't understand if the swear to is going to happen. He's in custody. I don't know why we couldn't add him to the list to have him arraigned on those 3 charges this afternoon and then set it 2 weeks out. But if you don't want me to do that,
That's fine with us, Your Honor.
all right.
I agree. Or 2 about what exactly is going to happen this afternoon. That maybe they can get him on the list to be arraigned as well. Certainly.
Zach Ward's involved.
Not. No.
If he's involved, this isn't going to happen.
I'll make sure he knows that.
All right. So if the officer's going to swear it out today, we communicate with the magistrate to see if they can get him arraigned and then set it for the 2nd? So I'll adjourn this out. Probable cause July 2nd, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Dominic Brewer.
Morning, Your Honor. Name is Cook for the people.
Good morning, Your Honor. Kyle Burnell on behalf of, but not with Mr. Brewer. Your Honor, it's my understanding that Mr. Brewer was picked up in Canton yesterday. Because of a hold that he had already. So I think it's my understanding, I believe he's in the Wayne County Jail or in the Canton lockup. I spoke to a family member yesterday late.
Well, we have it that yes, he was picked up. And they filed a conditional bond violation.
Okay.
All right.
Okay. Thank you. I wasn't aware of that bond violation, so thank you for that, Your Honor.
Yeah, this is the report. I think this is the Canton report that they then filed with this court, took him into custody down there.
Understood.
So at this point, what I will do though is I'll issue a bench warrant for his failure to appear. That way we can go get him. Bond will be setting him out of 10,000 cash surety.
Thank you, Judge.
Thank you. Court does call the case of the People versus Lorenzo Murphy.
Right, the people, Your Honor.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Lorenzo Murphy. Your Honor, we're asking for an adjournment in this matter. I just got this case. I was just appointed on it.
Are you on both cases?
Yes, Your Honor.
Need 2 weeks.
Yes, Your Honor.
July 2nd, 2026. Any bond continue.
Thank you,
sir. Court calls the case of the people versus Daryl Howell.
People. Good morning, Your Honor. Nathan Coulter requesting to zero. Prosecutor.
Michigan. Okay, permission to practice is granted.
Edward Rodriguez on behalf of Daryl Howell. Your Honor, I just was appointed. The contact information is not good. I don't have an email. I'd asked for an adjournment just for purposes of contact with him. I do have an address. I did mail him a letter yesterday, but I haven't got any confirmation back. I know he's on probation in Wayne County.
He's on probation in Wayne County?
On probation in Wayne County. So in the event that I reach him, if the court were to adjourn it, this is the first PC.
I understand that, but I think, given the nature of the charges, I'm going to issue a bench warrant for a surety to appear.
Okay.
Bond will be set at a 10,000 cash surety. We'll issue immediately. Thank you. Court does call the case, People versus Christopher Madison.
Bring it over to the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Madison.
In both matters.
In both matters, Your Honor.
Your name, sir?
Christopher Madison.
Thank you. You're requesting an adjournment.
Well, Your Honor, I did attempt to go speak to Mr. Madison yesterday. He indicated he may not want the services of the public defender anymore. So,
what? He doesn't want the services of the public defender? I'm going to hire his own?
No, I
Go ahead.
do a letter and I plead guilty on all charges, sir. So I figured I didn't need a public defender to plead guilty.
Okay. Mr. Madison? Did I receive this letter? I don't think so.
Top of my head, it did not sound good.
Yeah, I don't know that I've received a letter from you.
Oh.
Yeah, and why do you want to plead to 2 felonies?
Because I'm
5 years.
sir, I was under the influence of drugs.
yeah,
Okay, hold on. I don't want you to, well, just listen to this, Mr. Madison. I don't want you to say anything about the charges.
Okay.
Okay? I'm just trying to figure out why you want to proceed in that fashion, but hold on a second. Mr. Bukovich.
Your Honor, as I said, I don't want my client putting anything on the record that could incriminate himself. Obviously, he cannot plead at this stage. We're at the PC stage, which you cannot plead to a felony at the PC stage because this is a.
Oh, you can. Yeah, I don't take the plea.
You're not going to take the plea. So ultimately, I believe at this stage, our best option would be an adjournment for us to have time to consult with our client about the implications of a plea.
Let me ask you this, sir. If you're trying to get this done with.
Yes, sir. I'm trying.
Okay, hold on. It's not going to happen however it resolves itself. It's not going to happen less quickly or more quickly if you have an attorney, right?
Okay.
So I don't know. I think having the public defender is in your interest. The important thing, more so than it being quickly, is that all of your rights as you go through it and you go, whatever your decision is, your decision. But that to make sure that all your rights are protected. That's part of the reason that they're there and that your interest is protected. Okay. So I think what you should do, I'm going to adjourn these out a couple weeks. Okay. And then let you talk to the public defender, tell them what you want to do and talk it through with them. Okay. Fair enough. Okay. All right. I'll adjourn these to July 2nd, 2026, 9 a.m. Thank you, sir.
Thank you, Your Honor.
Court calls case, People versus Deontay Jordan.
Morning, Your Honor. Bring code to the people.
Good morning, Your Honor. J. Grant Miller, 58658 on behalf of Mr. Jordan. Your Honor, I was communicating with my client last night. He indicated having some transportation problems. He lives in Lansing. I encouraged him to get the bus down here. I would request
The whole bus thing, but go ahead.
Well, I did suggest the flyer does travel from Lansing to Ann Arbor, and then he can get the number 4 down here. Literally, I texted that to him, Your Honor. Not here. I understand that people are probably going to request something.
Bench warrant will issue for defendant's failure to appear. Bond is set in amount of $10,000 cash or surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court calls the case People versus Jason Smith.
Ready, Your Honor.
Morning, Your Honor.
Good morning, Your Honor. James Spifelski appearing on behalf of Jason Smith, who is approaching. Can you please state your name?
Jason Smith.
Thank you. Your Honor, this is our first PCC. I'm asking for an adjournment for discovery and investigation on this, please.
July 2nd, 2026, 9 a.m. without objection.
Thank you, Your Honor.
Bond continues.
Thank you, Judge.
Court calls the case People versus Janine Lebrel.
Morning, Your Honor. Raymond Cook for the people.
Praise.
For the record, Your Honor, Stuart Collis on behalf of Ms. Lebrel, who is approaching and coming to my right.
Hello, your name?
Jean LeBrow.
Thank you.
Your Honor, today for PCC, we are asking for an adjournment of this matter to do some further discovery. There's some videos that we need as well as some negotiation in this matter.
Probable cause conference will be set July 9th.
Very well. Your Honor,
26.
I have a brief request on the bond. My client has to go out of state for her nephew's birthday in Columbus, Ohio. And while I am sad that
to Ohio,
I know, right?
No, go ahead.
It's late June, and she obviously will be returning back where her partner home is. But
do we have travel dates?
Yes.
Yeah, it's the last Sunday in June for my nephew's first birthday. And I'll be staying with my parents.
So the 28th?
The intention is to drive down on the Saturday and then come back the Monday.
Saturday, 27th.
So 27th to the 29th. Any objection from the people?
No, Your Honor.
All right. Her bond will continue. You get me. You're doing it. And then I will allow her to travel to Ohio for those 3 days. Enjoy.
Very much, Your Honor. See you on the 9th. Thank you.
I'm sorry, Miss Zenda. I'm really sorry that you're from Ohio. Court calls the case. People versus Wardell Smith.
That is enough. You have to people, Your Honor.
Morning, Your Honor. Robert G. Kill on behalf of Wardell Smith.
Much better person having been in Michigan, but
Today's time for a PCC.
Your name, sir?
I'm sorry. We set this for exam.
Discovery is complete.
It's a reauthorization. Everything's the same. Yes.
All right. People have their witnesses available the 30th.
We'll do our best, Your Honor.
All right. Preliminary examination will be set for June 30th, 2026, 9 a.m. before Judge Barr.
Judge, may I make a bond argument?
May.
Judge, because this is reauthorization, the victim, who is the mother of his children, never showed the first time. That being, pardon? His wife. I'm sorry. His wife. Since he's been in jail since April 21st, he's done 3 weeks of Dawn Farm program. He could do that outpatient. He's also continuing with CMH. He could do that outpatient. Done a lot of really good programs in the jail. 12-step, the DV1, DV2. I know what the prosecutor is going to say, that he called the FBI. He admits he called the FBI. He was worried about his children. After he called the FBI, his son then called him, say, "Dad, everything's okay." He tried to cancel the FBI appointment. So again, it wasn't.
But that, I've heard this before. It wasn't just the call to the FBI. There were other calls that were also initiated by this defendant regarding police involvement?
Careful, what do you want to say? It was for the benefit of your children? Yeah, Judge, he did call, what, Pittsfield?
Yeah.
He did call Pittsfield. Again, it was concerned about his children, Judge. Again, there's a serious charge. We understand that, but my client could live with his mother in Ypsilanti. She's already said it's okay for him to live there, even if it were on tether. The other issue is, Judge, and I know this really doesn't go to the case, he has a lawn business that all his equipment is just in a storage area that's about to be repossessed and sold out. And we're asking the court to please consider just a reasonable bond for this man. He will stay away from the victim. And the calls he made were for the benefit of his children, who then called dad and said everything's fine so far.
Once again,
I'm going to object. While the defendant may say those were for the benefit of those children, some of those calls that involved him reporting a shooting, having law enforcement respond to that house for those children, basically, in a sense, swatting that residence for a shooting that did not occur. Beyond that, he did call the FBI, and there were also allegations of drug use while he was out on bond. I also have concerns given in one of his calls on the 15th, he mentions, I want to know if you can help me get back in good graces with my family, that I have a child with my wife. Tell her not to cut me out of the picture. Tell her that I still love her and I need her back now. I need some support. So I have concerns that he has shown this court time and time again that he cannot follow bond and is a danger to not only the victim, but the community and law enforcement by abusing their resources and having them to respond to things that are not happening. And also harassing this victim. And I mean, at this point, it was harassed because she came back around and was on board, because she was in fear for her life because of this defendant. So I think at this point, bond is appropriate, given that he has shown this court he cannot follow the orders of the court and is still even now attempting to try and get a hold of this victim. While not calling her directly, having other people in his family reach out to her.
That's what I was trying to do. Yeah, Judge, he said he was never trying to get a hold of the the victim. It was regarding his children. But this is the case. She never showed the first time. And again, I don't know if she's going to show the second time, but the court should.
But I've heard this bond argument before. I mean, I don't know of any circumstances that have changed from the court's perspective. It's actually gotten worse, quite frankly.
A reasonable bond to protect society.
I think the bond is reasonable. Motion denied. Court calls case of People versus Tariq Wilson.
Assistant Public Defendant Nick Bukovich on behalf of Mr. Wilson.
Mr. Wilson, is there somebody you can ask to help unmute? Good morning.
All right.
Okay.
Okay.
Thank you.
Yes, welcome.
Thank Mr. Wilson, can you state your name, please, sir?
Eric Wilson.
Thank you. You're asking for an adjournment.
Yes, Your Honor. I filled out the visit application. I'm just waiting for a response. So
How fast do you typically respond? Do you know?
well, they told me it would take 2 days to process that, but apparently that may not have been true because I sent it more than 2 days ago.
All right. He's in MDOC.
Yes, he is.
I think the court's familiar with those. Mine, it could take weeks.
Yeah. All right. Let me adjourn this out to July 16th. Won't affect defendant's custody status. July 16th, 2026, 90.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Court calls case of the People versus Natasha Brazelton.
Morning, Your Honor. Raymond Cook for the People.
And Assistant Public Defendant Nick Bukovich on behalf of Ms. Brazelton. should be appearing via Zoom.
Not checked in.
Your Honor, I did speak to Ms. Brazelton this week. We were playing a little bit of phone tag. We do have a finalized offer, so I cannot explain her lack of appearance here today. However, I did speak to her this week, so I would be requesting an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount $10,000 cash here.
A packed courtroom session revealed multiple turning points as defendants faced serious legal decisions, bond issues, and plea negotiations. Anthony Halston appeared before the court and entered a no-contest plea to aggravated assault, accepting the consequences while the judge carefully explained his rights and the impact of the decision. But one of the most intense moments came when Christopher Madison tried to quickly plead guilty, telling the court he wanted to resolve everything immediately. The judge stopped the process, reminding him that protecting his rights and having proper legal guidance mattered more than rushing a decision. Later, a heated bond argument unfolded for Wardell Smith, where the defense highlighted rehabilitation efforts and personal circumstances, while prosecutors raised concerns about alleged violations and community safety. After hearing both sides, the judge denied the request for a lower bond. From plea deals to bond battles, this hearing showed how every decision in court can dramatically impact a defendant's future.